everybody. My name's Amanda. Thank you so much for joining me this evening to talk about our rights as tenants. I am going to go ahead and get started so I can be mindful of everybody's time. And I apologize if the sun lighting gets weird. But before I get started, again, my name's Amanda. I work for Unite Oregon and the Anti-Displacement PDX Coalition. And I will be doing a quick Renters' Rights 101 workshop for you this evening. I'll be assisted by Krishna, who you'll see in the chat. They are going to make sure that everything on Zoom is going well, that if people have questions in the chat that I don't answer right away, that they're recorded and that you do get a response. If not during the presentation, that we make sure to include a response when we send out any sort of follow-up emails. And other than that, I think that we are good to get started. As I said, my name's Amanda. I use she and they pronouns. And the reason I'm presenting to you all today is because I went to law school at Lewis and Clark. And during my time as a law student, I had the privilege of working at Student Legal Services at Portland State University. And during that time, I learned a lot about not only just landlord-tenant law, but how to, as a tenant myself, protect my rights as a renter. And I want to be able to share all of that with you today. And of course, Krishna, if you think I'm missing anything or there's any technical difficulties, feel free to unmute and let me know. But the last thing I can say on this front slide is our workshop is funded by the Portland Housing Bureau and the Urban League of Portland. And we're really happy to be able to be here with you today. So today's agenda is going to start with an introduction. It is a bit top heavy. And what I mean by that is we're going to spend quite a bit of time right at the beginning with me talking at you all about the laws, the landlord-tenant laws, but also just laws generally and how you can tell whether something's a federal law, a state law, or a local law. And the reason that matters is because say that you have a dispute with your landlord or somebody that you really love and care about goes through a situation and you don't think anyone else should ever have to go through that situation. It's really important that you know who and at what level of government you're going to need to be organizing for and against or with, right? But that you need to understand where those laws come from to be able to actually understand what the remedy would be for you. So we'll talk about understanding the laws, and then from there, we're going to go through different things that are important to know from when you're applying as a tenant, when you are moving into your new unit, during your tenancy, when you move out, and then finally some resources for what you can do if you receive an eviction notice. And then finally, if we have time, Krishna and I will be able to share with you some information about the resource referral program that Unite offers there at the end. So I like to let people know what my goal is. So my goal today is to provide information and a space where we can build our collective understanding and through that build community power so that we can help each other and ourselves throughout, this process that is life, but also through the complicated process that can be renting a unit. Some important kind of housekeeping or logistical notes is today the information that's shared is not the equivalent of legal advice, does not constitute legal advice. While I have a law degree, I am not a licensed attorney, and therefore I am not qualified to give you or anyone else legal advice. So if you think that something in today's presentation that triggers a thought in you that you're like, actually, I think my rights have been violated, or I think they might be being violated, or I feel like I really need to talk to somebody, we have resources and can refer you to those resources. And we would encourage you to do so to make sure that you're protecting yourself and that you have an accurate understanding of what's going on. Because something that's really important to me that people understand is the law is not a answer to all of our problems. A lot of times the law is our problems, but when it comes to different legal issues, lawyers are often in the position of telling people, oh, this experience that you're having is not something that they can help with the law. What that can feel like, or at least what it's felt like for me when I've been on the other side of it, is that if people are invalidating your experience or saying that something that you went through wasn't awful enough for you to be able to have some legal ramification or some acknowledgement from a kind of formal body that what happened to you was incorrect. And so just know that today when we're sharing information, even if there's not a legal remedy for what you went through is still extremely valid. And I don't ever want to make people feel like we are trying to say that something that they've gone through doesn't matter or isn't important. It's just certain things don't have legal answers. And that doesn't mean to find illegal answers. It just means that that might not be the best avenue for you to spend your energy or time. And we want to save your energy or time because we don't have enough. Everyone has 24 hours in a day. So the next sort of housekeeping is just to note that there's no guaranteed compensation for attending today's event. So if you're here today, we are really happy to have you. However, just know that we only have 10 gift cards to give out. If you've received a gift card already from a prior training on landlord-tenant issues, you will not be entered into the drawing. And if you're not a local to Oregon resident, we are not able to give you any sort of compensation just based on the grants that we're working under. Like I said, I'm working under a grant with the Portland Housing Bureau. So things have to stay relatively local. Being in Oregon is just fine. But I just want to note that that's 10 participants who finished the exit survey and attended today's event will be entered into a raffle to receive a $25 electronic gift card, but not everybody who attends the event is ensured that. Hopefully, if we get more funding in the future, we could change that. But as of right now, I just want to be really clear with everyone and not get anyone's expectations up. The next point is a lot of the training's material today I tried to make very much applicable for all Oregon residents. But again, we're funded by Portland Housing Bureau, so we're centering and making sure that we're also providing information for Portland residents that might not apply to folks that are in Rogue Valley or folks that are in a different county or city. The next item is to please ask questions. If you can ask questions in the chat, that's great. And either Krishna will let me know, hey, you should answer this now, or we have a really good question in the chat. But also Krishna knows what our presentation material looks like. So they might also be holding on to your question to ask me at a time that fits better in the presentation. So just know that that is there. And I will try to stop at different sections to drink water, but also to check in with you all and see if anyone has a question about something that was shared in that section that we can sort of talk out. One of the things that's really beneficial about these workshops is getting to hear what our neighbors are also experiencing. A topic that we'll go into in depth is going to be discrimination and what our rights are around fair housing laws. Discrimination is one of those interesting things because by definition, it means that you're being treated differently, usually in a negative way, based on a certain protected characteristic. Protected just means kind of what I was saying before, that the law actually does have some sort of remedy for that, and that they've taken the time to draft and pass legislation to make sure that they're able to protect people's rights against discrimination for a certain amount of things. You don't know if you're usually I should say, you won't know if you're being discriminated against unless you're talking to other people that are in a similar relationship with the landlord or management company that you are. So sharing is caring, it really is, but also sharing a lot of times is what allows us to realize that we're being treated unfairly. Let me just double check. Okay, so again, compensation is not guaranteed for that $25 gift card. unfortunately, if that's why you're here today, is just to collect that, I wouldn't bank on this. It's not the most best way for you to get that money. It's a raffle, so it's going to depend on who all submits their exit surveys, and we will be deciding on Mondays when we'll do the drawing, but then it still takes some time for gift cards to be distributed. And yeah, so back to the presentation. The opposite of poverty is not wealth. The opposite of poverty is justice. This is a quote by Bryan Stevenson that I think really shapes a lot of what we're going to talk about today. So our first topic is understanding the basics of landlord-tenant laws. This, like I said at the beginning, is the very technical, not so fun parts, but can be really helpful to understanding the rest of the information. Starting with some important terms and definitions. What do we mean when we say landlord-tenant law? What is that? Landlord-tenant law just refers to the body or group of laws that legally define the rights and responsibilities of renters and landlords, and also their relationships to one another. For the purposes of our presentation today, we want to work with definitions for landlord, as a landlord is a person who rents land, a building, a room, or an apartment to a tenant. Again, for today's presentation, and also when you're thinking about landlord-tenant law, you can think of the landlord and a property manager or property management as the same thing, because when a landlord hires, or when a homeowner, I should say, hires a property manager, the management is acting as an agent of the landlord. So legally speaking, for you as a tenant, anything that property management company holds out and says, even if later on a different company takes over or whatnot, like the new company is still going to be held to the commitments that the other company made. That's also true if you have say that you're renting a home in a duplex, and you know who the homeowner is, that's who the landlord is, they're not hiring a property manager at that time. It's still going to be the same sort of legal relationship as it would be if you lived in a big apartment complex and you don't know who owns the building at all. All that matters is that there's somebody there who's either holding themselves out and saying, I am the landlord, or I am the property management or manager, or I represent the property manager or the landlord. Similarly, a tenant is the person that's renting that piece of property. So tenants, renters, same thing. So in the presentation, if we go back and forth and refer to tenant rights, renters' rights, those are completely overlapping circles if they were a Venn diagram. And I did try to share in the presentation, if you see things that are underlined like this, those are links that after the presentation, when you get an email later this week, if you're going through the slides yourself, because we will send these out to you all, you can click on different things and it'll take you directly to websites to allow you to learn more. And let's see. So for the body of laws, the landlord-tenant laws, some of the laws are statewide, meaning that anybody who is a renter, who's not living on tribal land or military, on like military barracks, these laws should apply to you. The statutes that, when I say statutes, that's just a fancy word for laws that went through the Congress of our state. So laws that had been, we vote for people to be in office, and then those people are supposed to represent our issues in our local Oregon Congress. The things that come out of that are statutes. And the section of the Oregon Revised Statutes, or ORS, that represent landlord-tenant law are all in Chapter 90. So if you just get really curious and you type in ORS Chapter 90 into Google, it will produce the Oregon revised statutes, and it will start to talk about, pull up different links that are relevant to resident, landlord, tenant, and residential rentals. So some laws that will apply potentially to you, depending on where you live, are going to be local to your city or county. Those are usually called county or municipal or city ordinances. There's also regulations or housing codes that can be more specific than the Oregon statewide laws. So if you've heard of the Portland City Code, that's PCC 30 point whatever. I only share the examples so that if you see it somewhere and you see that ORS Chapter 90, you can tell, okay, this is a statewide thing. So this is something that applies broadly to tenants across the state, versus if you see something that says PCC and you happen to not live in Portland anymore, maybe you moved to Beaverton, maybe you moved to Eugene, that you would know, okay, if a protection for renters that I'm kind of relying on to understand some sort of issue that you're having in your renting process, it says PCC and you live in Eugene, well, now okay, I need to do some more research or contact a legal professional to figure out whether or not this Portland City Code has a similar code that has been put into place in Eugene or wherever it is that you live. It doesn't mean just because you see that Portland City Code thing that it for sure doesn't apply to you. It just means that you got to do a little bit more work to just double check and make sure. So to break down some of the actual laws that represent our rights as tenants, there's statewide protections, as we've talked about, Oregon revised statutes or ORS Chapter 90. And then there's also Senate Bill 608, which was a bill that was passed in, I believe it was February 28th of 2019 is when Governor Brown signed that law. The goal was to protect renters from big increases when they were renewing a lease. So they created a cap on how much a landlord could increase rent between tenancies. And then they also just created different requirements for landlords to be able to justify fees or things of the like. The goal was to keep or to try to push back against how expensive it's been, like housing affordability in Portland is not thriving. I'm sure those of us in this space are probably very aware. It's expensive to live here, and the services that we receive in response for that increase in rent, they're not quite matching up. And so in 2019, a lot of the advocates around housing issues were able to at least try to promote something to keep the rent from increasing more than like 10%. And we'll talk more about these laws specifically throughout the presentation. Today's presentation and many others, it'll be kind of repetitive because the goal is that hearing the same information in different ways throughout the presentation might sit with some people better than others, or might help kind of round out our understanding of a concept. And then we will also talk about, and I apologize if I don't know if you all can see this little Zoom bar, but we'll also talk about Portland specific tenant protections that are mostly through the FAIR laws, the Fair Access and Renting housing laws. And if you don't live in Portland and you're like, wow, I really wish that we had some of these protections that are specific to Portland, that's great. Let's talk about organizing, and let's talk about advocating and being able to create the sort of framework that we want to live in or want to see. So this is a lot of words. You're not supposed to have this many words on a slide, but the reason that I do is because I know we're sending these out to you all after the fact. And so if you want to be able to read through all of the slides yourself and do your own research and look into it, you have the ability to do that. The Oregon Revised Statutes, Chapter 90, we went over. That's a statewide legal framework to try to balance out the relations between landlords and tenants. In that Chapter 90, it's going to cover things like rental agreements and lease terms, security deposits and application fees, maintenance and repair duties or obligations, rent increases and termination of tenancy rules. That just means when can they increase your rent, by how much, and how can a tenant or a landlord end a tenancy. So they don't want to be in a relationship anymore. Tenant doesn't want to live there. Landlord doesn't want them to live there. How do they get out of that? We'll also talk about some protections against discrimination and retaliation and the eviction process and tenant remedies. All of those, generally the statewide ones, are going to live in that Chapter 90 section. Senate Bill 608 we went over. It covers things like the annual rent increase. It was the first law in Oregon to actually create a limit on how much your rent could be increased. Like I said, that was only in 2019. So there's still a lot of room for growth and better protections in that area. There's also more restrictions under Senate Bill 608 against no-cause evictions. So what that meant is that landlords would have to provide a valid, legally justifiable reason for eviction or to terminate a tenancy. There are exceptions. With anything we talk about today, there almost always are exceptions because the law is not that simple. Why law school wouldn't be so expensive, and neither would lawyers, if the law was made to be easily understood. And it's not, and it's made to be debatable. So know that when we're talking about things today, you always want to go talk to somebody that is a legal professional before you make any sort of big decisions that could impact your housing. Ultimate goal, want to keep you where you want to live if that's where you want to be. And so make sure you talk to somebody before you take any sort of actions, talking to your landlord or things like that. Senate Bill 608 also tries to keep people who have been living somewhere for more than a year where they are, is they want to be there. Basically protecting the rights of tenants and trying to keep them in conditions that would allow them to stay where they're living, to not be displaced, if that's what they want. So at the bottom here of this slide, I underlined is this Oregon Housing Alliance SB 608 explanation video. If you click on that, there's about a 3-minute video that walks through all the specifics of that bill. For the fair housing laws, this last section here, this third column, these are the laws that I talked about as being Portland specific. So they're not statewide yet. Could be cool if they were. And if you become really passionate about any of the laws here and you think they should be statewide, or you think they should pass something similar where you live, come talk to us. I'm sure we would love to hear both your ideas, but also to be able to know what you're passionate about, so that when we're in tables and by tables, I mean Zoom meetings like this, when we're in these sort of spaces with people from the government, people from other organizations that are asking us, hey, what do renters want? What are they struggling with? How do we prioritize a list of different housing, priorities? Then we can actually respond and say, well, I had a training in August. I talked to several different people. They all happened to tell me that they were having the same issues with black mold, or they were having the same issues with landlords not responding to their emails. That kind of information we can then take into those spaces and try to kind of push forward in real time and let people know that folks are struggling and what they're struggling with, and advocate for them to fix it. So The fair housing laws are aimed at trying to make the application process and the rental process more fair. It tried to strengthen different protections for tenants against discrimination. It also enacted different rules that make it so landlords have to respond to tenants or process their applications within 60 days. It put a cap on how much an application fee can be. And then it also created some very specific protections for applicants with disabilities. We're getting close to the end of the law part, so bear with me. Another important thing to know is that there are a couple types of leases. There are month-to-month leases and fixed-term leases. A month-to-month lease is a lease that is going to continue on a month-to-month basis. It doesn't have a set end date. It doesn't necessarily even have to be in writing. And the benefit of a month-to-month lease is that it gives you flexibility. It does not necessarily give you reliability or stability. So a fixed term lease, in comparison, is a rental agreement that has a specific start date and a specific stop date. So both the landlord and tenant have said that a tenant is going to pay a certain amount for a certain amount of time to have access to that rental unit and to be able to live in that rental unit. Neither the landlord or the tenant can just by themselves decide to change terms of the agreement. The fixed term lease, if it's for 12 months or more, has to be in writing, and therefore any adjustments to that agreement also have to be in writing. At the end of a fixed term lease in the state of Oregon, and this is pretty unique, in the state of Oregon, when your lease expires, if you haven't received a notice to vacate and you have not provided the landlord with a notice to vacate, your fixed term lease becomes usually a month-to-month lease. Typically your rental agreement will say that at the end of this lease term, after the expiration date, if it transitions into a month-to-month lease, usually the rent is a little bit higher. The reason for that is because the same kind of stability issue that you would have as a renter, the landlord has. So for them to make up for the fact that they can't guarantee they're going to have somebody paying month after month after month for that place, they usually will increase the cost of the monthly rent. Either tenant or landlord can provide a 30-day notice to vacate in a month-to-month lease, and there's no penalty for that. You're both allowed to say, I'm done here, here's my 30-day notice, and then 30 days from that is when you can leave. However, from the tenant perspective, that also means that the landlord has more flexibility to be able to change terms of the lease as long as they also give you 30 days notice. So they could decide they want to increase your rent. They could decide that they no longer want to allow access to the swimming pool or something, or they think parking is no longer included in what they want to offer in that rental agreement. They have the flexibility to be able to do that on a month-to-month lease. They cannot do that on a fixed term lease. Neither party can just change terms of the lease just because they want to on their own. They have to come to some sort of agreement with the landlord. And if the original, if their rental agreement is signed and in writing, then the changes to that rental agreement also need to be in writing. In general, as you'll know throughout the presentation, I will encourage you to get as much in writing from your landlord as you can, even really simple things, because ultimately you're just trying to reduce stress for yourself down the road. If there is a conflict, if something happens, having evidence makes things a lot less stressful for how you end up going through that process. And I share that as somebody who has gone through a lawsuit with prior landlords. So it's a lot better to have good evidence, because then you're not just relying on, the one person said this, the other person said this, or a landlord or a tenant both having different memories of how a conversation went down, or different memories of what that conversation means. Just having stuff in writing is just really helpful for that. So the big kind of, I guess, negative that you could associate with the fixed term lease is that there's usually a lease break penalty. So that means if you're trying to end your lease early, unlike in the month-to-month lease where you can just submit your 30-day notice and, within 30 days you're good to go. No fee associated with that. For a fixed term lease, usually in your rental agreement, there will also be a lease break penalty or early termination fee. And that fee is to deal with the fact that, this landlord, they're making a business decision, they're relying on you as a tenant to fulfill the duties, paying rent and living in that place, keeping it in good quality until the end of the lease. So if that doesn't happen, the penalty is that there's a fee associated with it. So again, fixed term lease can bring you stability because it holds that rent and whatever the terms that you signed on to. It's going to keep those for the entirety of that lease. But it also means that you have to stay there or pay the fee to be able to leave. Well, you can leave, but you might still have to pay for the unit. So that was the really fun legalese portion. The main things that I just really want to emphasize is giving you all the tools to be able to look this stuff up once this presentation is over or in the future, and be able to know, okay, why did I hear something in a presentation that said I had a right to this, but now it doesn't seem like that applies to me? And then if you look at it and you're like, well, I don't live in Portland, and this was Portland specific because it was a city ordinance, that you're able to differentiate those things and it doesn't become overwhelming. For the rest of our presentation, which we have about a little less than an hour left, we'll go through the application phase, moving in, living at your new unit, and then moving out, and talk about different protections as they exist. Again, there's a lot more words on these slides than I expect anyone to take in as we're going through the presentation. The goal is that this exposes you to different concepts and makes it so that when you hear some of these really specific terms to landlord-tenant law or landlord-tenant issues, you know what people are talking about. And if you don't know, that you know where you can go to get the information to figure it out. So for the application phase, a lot of the laws are from all of the laws are from those sources we talked about at the beginning, but there is a fair amount of fair housing law explanation that comes out. I do promise that after the applying for a rental stage, the other sections are a lot less text heavy and a lot more fun, in my opinion. The applying portion takes more time because it's the portion in which a lot of times that's like where discrimination occurs, is in refusing to rent to people because they don't fit a certain a certain characteristic, or just being treated unfairly. And that's why we spend quite a bit of time here. So statewide, we all, as renters, have a right against discrimination from housing. So if somebody says they don't want to rent to us, they don't want to rent to you on the basis of your race, color, religion, national origin, disability, family status, sex, and in Multnomah County, age. This can show up in a variety of ways, but some examples of illegal discrimination include refusing to rent to somebody on the basis of one of those protected characteristics, those items, race, color, religion, that list, those are protected characteristics. So if somebody refuses to rent to you and it's very obvious, maybe they said they don't like your kind, maybe they said something in a certain way that you're just, it strikes you as you're being discriminated against, you're being treated differently because of one of those characteristics. That is a time you want to go seek out one of these legal resources. You want to call the Community Alliance of Tenants and get an opinion. There are a lot of protections against that kind of behavior. If there are different rental terms that are being provided to you and you have a suspicion, it is because you have one of those protected characteristics and the other people in the facility or place that you're renting don't. Well, that's going to be another time that you want to seek out those legal resources and expertise. But also, how would you know that somebody is setting different rental terms for you versus your neighbor if you don't talk to your neighbor, right? Like, that's not information that the landlord is going to provide to you in most situations, if ever. A lot of the times they might not even know that what they're doing is discriminatory. So that's just kind of a little plug to, talk to each other and build community where you are, because we are so much stronger together than we are apart. And it's really hard to tell if you're being treated differently if you don't talk to other people about how they're being treated. Other examples include making discriminatory statements and intimidating or coercing renters. So intimidation can be pretty much anything to just try to make you feel uncomfortable and make you act in a certain type of way. And then coercion is pretty similar, but usually has something to do with some material benefit. So maybe they make it seem like they're going to knock off a few bucks here or there. If somebody else decides that they're not going to talk to you about your landlord situation, or basically anything to try to get you to act a certain type of way using the power that they have, either financially, either because they are the ones who could file for, an eviction if they wanted to, say that they make certain statements that seem obvious that they're trying to threaten you with immigration, saying they're going to call ICE, or just making references to ICE, stuff like that. Those are times, again, you're going to want to follow up and investigate. Because it's probably not legal. And if you're here in the state of Oregon, you have some protections for that. If you are somebody who has a disability, or somebody you care about has a disability, and you're trying to help them navigate the application process as a renter, there are a few things to note. One of those things is landlords in Oregon have to review applications on a first come, first serve basis. So once they get a completed application, they have to review it and process it. Right then and there, they can't pick favorites from the pile. So if they got 5 applications at the same time, 4 of those applicants are from their college, fraternity brothers, or their best friends, or something. And one's just a normal stranger who also saw the listing and applied. And that normal stranger happened to be the first one by a millisecond to get their application submitted and completed. They need to be reviewed first. And if they meet all of the screening criteria, which have to be shared with the applicant, the landlord has to tell you what they're using to decide if you can or cannot live there. If you go through all of those things and they don't have a valid reason to deny, then that rental unit goes to that person. There are exceptions, and we'll get to them momentarily. Those exceptions are that if you are somebody who has a qualified disability and you're applying and you have the documentation to support that you have that disability, the landlord then, even if all those applications came in at the same time, would have to evaluate the person who identified they have a disability first. The reason for that is because there's just not that many places to live that are accessible for people who have different disabilities. So in order to try to get people to homes that actually need the features of those homes. That's why that exists. It's also to try to keep landlords from not renting to people with disabilities. Because a landlord might assume or think that, renting to people who have a disability is going to cost them more money because they might have to install different features for reasonable accommodations or things like that. And so to prevent against landlords from being able to say, well, I don't want to deal with it. That might never happen with this particular person based on their disability, but I just don't rent to disabled people. That's just not I just don't do that. It's a bad business decision for me. This law was passed to sort of counter that and make it so that they can't just make blanket sort of determinations that way and keep people housed who need different features for access. On the renter side, to try to, be able to say that you have a disability and that you should qualify for these different rights, you may need to provide documentation of the disability and of the specific need for the reasonable accommodation. Reasonable accommodations can take many, many different forms. It depends on what the person's needs are. But for example, maybe if somebody is blind and they are applying and the rental application was just a paper application, it's not something that they're able to run through a service that is going to read the text out loud. It's not providing them with any of that kind of background, so they cannot complete the application unless an alternative format is created. That could be considered a reasonable accommodation for that. Having additional assistance in completing the application could also be a reasonable accommodation. And yeah, there's a lot of examples of what that could look like. But if you are somebody who has a disability, who's really struggling in the renting process, or just wants to make sure that your rights are not being violated along the way, there's a bunch of different organizations. Disability Rights Oregon is one that you can reach out to. They have a lot of resources already just on their website so that people can get their own knowledge up, but also you can also send in a contact form and describe the situation that you're in and why you would like to talk to somebody. They can help you. The last thing I'll say on this is about assistance animals. Assistance animals can divide into different categories. Emotional support animals, or ESAs, are not legally qualified service animals. Service animals are a separate category. From that, service animals go through very, very regulated training, and they have to have very specific, behaviors and not have a lot of specific behaviors in order to maintain that status. Emotional support animals are different. Emotional support animals still serve an incredibly important purpose, but as far as their legal protections, I just want to note that there are going to be certain times that a service animal is going to be allowed in different spaces that emotional support animals are not. For here, in our landlord-tenant renting sort of categories, that's not the case. If you have an emotional support animal, that still qualifies and can be a assistance animal, as long as you have the medical diagnoses and support from a medical professional necessary for the animal to have that designation. And so if you have a service animal or an emotional support animal, those are not subject to no pet policies. So you could still potentially live somewhere that has a no pets policy with an emotional support or a service animal, and you would not be, the landlord could not then charge you for a pet deposit or any sort of fees for that. They can, however, still keep your security deposit or portions of it, or charge you for damage done by the pet, regardless of its qualification. So those things are important. Assistance animals, though, if they do anything to pose a threat to other people living in the building, or, there's basically that. If they end up posing an actual physical sort of threat, they get bitey, then they're very likely to lose that designation as an emotional support animal. And if you do live somewhere that has no pets rules and it loses that designation, you got to go talk to somebody. That's going to be a situation that you're going to want to get some support on, because now your housing situation is compromised unless you are able to find somewhere else for your pet to go. So we talked about some of this already, that landlords must review the applications in the order that they're received, with the exception for applicants with disabilities. Landlords also have to notify you within 60 days of receiving a completed application of the status of your application. Because of that rule above, that first come, first serve rule, that is a big incentive for landlords to process applications in a timely manner, and tell people where they're at in the process. If somebody who's paid for an application fee is denied, they have the right to get a written explanation of why they were denied, and also a refund of their application fee. Again, there's a prohibition on discrimination. Basically, it means it's illegal to discriminate. That doesn't mean discrimination doesn't happen every day. Like I said, a lot of times people don't know what is or isn't discrimination. A lot of times people might have a different interpretation of events that makes one person think discrimination happened and the other is like, it didn't. It absolutely didn't. So it's important just to be aware of when you should be consulting a second opinion, or when you should consider talking to your neighbors, seeing if they're going through the same thing. So can't legally discriminate, but as we know, illegal things happen often. Go ahead, Krishna.
Yeah, Amanda. So Sophia Diaz in the chat basically just said, are you required, or I guess she had a question basically asking, are you required to pay a pet deposit for emotional support animals?
Okay, and I think I'm just looking at that. Thanks, Krishna. And I believe I'm going to say, I think Sophia uses they, them pronouns based on their description there. But the question is, are you required to pay a pet deposit for emotional support animals? No. If your animal is an emotional support animal, they can't charge you for a pet deposit, pet rent, anything like that. They can only charge you for damage done by the animal. So but that also is something that a lot of landlords don't know. And so that does happen relatively often. It just means that now you might have to figure out how you want to talk to the landlord. Maybe you want to let them know that here's what the law says, etc. Maybe that's not the avenue that you want to take and you want to do something else. But if you've been charged a fee, for something that you don't think is reasonable or legal, that's again a great time to call that Community Alliance of Tenants hotline, or to contact a legal service provider. If you happen to be a student at Portland State University, Student Legal Services is a service that your tuition is already paying for, so go talk to them and get some advice. But they should not be charging a pet deposit for an emotional support animal. I will note, though, that sometimes you might move into a place and then later on get that designation. So you may have moved in when Fluffy was not yet qualified as an emotional support animal, or maybe you didn't have a therapist yet or somebody to say that that's what this animal was, and then it happens after the fact. Okay, well then that might be something that you need to notify your landlord of in order for that refund to happen or for that process to take place. But again, that's when you want to reach out, because all of our renter situations are so specific to what lease agreements we've signed and where we are. But hopefully that is helpful. Okay, great. So I think we got through everything. Oh, nope. Two very important bullets are at the bottom. Landlords must accept any reasonable forms of identification. What that means is that a landlord can't demand that they want to see a passport and a driver's license, or they want your social security number and an insurance card, or just having really specific requirements for you to prove your identity in order to keep landlords from being able to take advantage or try to create just sort of different requirements that they knew people wouldn't be able to meet so that they could deny their application. These types of rules were implemented. So as long as you're submitting multiple forms of identification that are reasonable in combination to prove that you are who you say you are, that should be sufficient. However, just like before when I said discrimination is illegal, but it happens all the time. There's certain words that for me with that law training make my little like light bulb thing or orange flag go up. One of those words is reasonable. Who gets to determine what is and is not a reasonable form of identification? You know, it might be different. Judge to judge, it might be different in a lot of different contexts. So just keep that in mind. That reasonable to who, for who is always going to be relevant. And then the last bullet here is about the minimum income requirement. So sometimes when you're renting a place, they'll say that one of the things when you're doing the application that they say they're looking for is that you have to make a certain amount more than the monthly rent. In Oregon, they can't require that you make more than 1.5 times what that monthly rent is. So somebody can't say they don't want to rent to you because even though the rent's $1,000 a month, they want you to prove that you can pay $10,000 a month. Like that's not going to fly. Fees. Don't we love fees? So statewide, the maximum is $50 per application per person. Per applicant, per person. And they, when charging an application fee, have to say what that fee is for. Typically it's going to be for like credit checks, background checks. If they're doing any sort of references, maybe they hire a company that does those things for them. A lot of times it's the property management company that's doing those reviews or hiring the other companies to do those background checks. When they're charging you for an application fee, they just have to give you a list of where that money is going. I think for my last time I did one, it was $15 per person for that application. And that was pretty standard. I've seen also people pay $30, $35, $40 for an application. That's again, unfortunately standard. If you're moving into affordable housing, so if you're moving into housing that has certain income restrictions, or you pay rent based on what your income is, that's going to be different. There's different protections for people and different limits on how much those fees can be if you make 50% or below the median poverty level for your area. I think we said this before, but applicants who are denied receive a refund. They're supposed to receive that refund within 20 days. So I've never encountered that situation, so I'm not sure that happens a lot. People actually get their money back, or if because they're looking for somewhere to live, they're moving on to the next, application as soon as they get that denial. But technically, they are entitled to a refund of their application if they are denied, and that landlords can only charge one application fee per applicant per unit. And those things I just read off are statewide. Now, if we zoom in to Portland, all of those statewide protections apply, but also this is where some of those income requirements come into play. Landlords must waive an application fee for any applicant who can demonstrate that their income is at or below 50% of the area's median income. Again, reaching out to different resources or doing some of your own research online, you can figure out what that median income is for your area if you just type into the Googles or whatever search engine you prefer. If you just type in, Portland median income or area median income, that'll probably give you results that will help you figure out what that level is for wherever you are. And you don't even have to say, Portland. It can be wherever you are living. There's going to be different costs of living in different places, even in our state. So actually, even just in Portland alone, but that will help you to kind of be able to figure out what that is for you. And also in Portland, there is a difference. So they created a new category. So when you're applying, you can have applicant tenants and non-applicant tenants on a lease. What that means is anyone who's listed as an applicant tenant, their financials are going to be reviewed. So they need to prove the income requirement. They might need to have a certain credit score. They can have those different things. However, say that I am in a relationship and the person I'm in a relationship with, they just don't have a good credit score. Maybe, life happens. It happens to everyone. So for whatever reason, they have a credit score, they have a financial history that a landlord might want to, reject the whole application based on just their financials alone. But you make enough. You and maybe the other people that are living there, or just you yourself, are able to say, I meet all of these income requirements. I meet all of these base standards on my own. So I'm still going to list that this person would be moving in with me and that they have, they would still be on the lease and have legal rights to the space, but I don't want their financials to be considered. You can do that. That they still will run a criminal history. So the person who's moving in with you, if they have a criminal history that makes them ineligible for moving into that space, that could still be used to reject your overall application. But if it's something like you have a family member moving in with you, you just live with somebody that their scores or something about their financial history makes you think that your application is more likely to be denied if they review their finances, you can list them as a non-applicant tenant. The last thing here is for the minimum income requirement, that the cap is that they can't require a tenant to make more than 2.5 times the monthly rent. So they can require that you regularly, your income shows that you make 2.5 times what the monthly rent is. If they try to do 2.6 times the monthly rent, that's too high. Can't do that. But that is a protection for folks here in Portland. Finally, under the fair housing laws, they have a rule for supplemental evidence. Supplemental evidence is just anything that's not required by the application that you're sending in with the application. So as we talked about before, life happens to everybody. Maybe somebody had a situation in which they were struggling with addiction. They were in a bad relationship. They were in a bad relationship with somebody struggling with addiction, whatever it might be. And through that process, they got a bunch of debt or they weren't paying certain bills on time. And because of that, again, that pesky credit history is not where they want it to be. But maybe they tanked their credit history like 10 years ago or 5 years ago, or even 2 years ago, or a year ago. Recovery can happen at different speeds for different people. But if they're able to now make the other requirements, they meet the income requirement, they meet everything else, but they're really worried because they're like, ugh, I had bad credit for, 30 years and I'm trying to repair it in this shorter window of time. And repairing credit is weird because it's a weird process. Like just credit as a system itself is strange. So it takes time. So maybe as an applicant, you're worried if a landlord is going to review your application and they just see what's there, your concern is that they might fill in the gaps with their, imagination or, worst case scenarios. And you just know that whatever they're going to imagine, that doesn't fit you or your situation. And you just want to clarify. Supplemental evidence can be one way to do that. It can be a letter. It could be you showing that you participated in a treatment program and graduated. It could be a note from a doctor, maybe a note from a professional reference. I've seen people who have religious leaders, so their pastor, their rabbi, submit some sort of, reference or recommendation. Things like that can end up being helpful. But it basically, the way I think of it is as a gap filler. So you don't want someone's imagination running away with something. You definitely don't want to be rejected because of a misinterpretation of what the information on that application is saying. So you fill in the gaps yourself. So security deposits are going to come up a few times. Security deposits are the amount of money that a tenant pays to a landlord at the start of a rental agreement. The landlord holds on to that money as a sort of insurance policy during the tenancy. The security deposit is just supposed to cover any damages beyond normal wear and tear. Another fun legal term, like reasonable, beyond normal wear and tear. That just means that the condition of the unit is beyond what just time and somebody just living in a place would do to it. So for example, with a rental unit, you can move into a place and treat it wonderfully, clean it every day, not do any sort of damage, and be perfect. But still, as it ages, it's naturally going to be worse off than when you got there. So when they say beyond normal wear and tear, that's what they're referring to, is just the normal sort of things. Like you shouldn't be charged for a building aging. That's not on you. But if you burned a bunch of holes in the carpet and the building is aging, well, maybe the building aging, that's not on you, but those holes in the carpet, those are probably going to come right out of that security deposit. And so that's kind of a way to think about it. Another thing to think about is carpet. Places that have carpet in Oregon, they have like a specific way of measuring how much a landlord can try to recover from a tenant based on how old the carpet is. I believe it's 11 years is like the life cycle that they think of as a carpet, but I could be wrong. But the example being, if you moved into a place on it and the carpet was installed, 11 years prior, and you're there year 8, or sorry, not 11 years, but that carpet was installed 8 years prior, you move in there. When you move out, they say that they are charging you to replace carpet in the entire building, or in the entire unit that you rented. And you're like, the carpet was not very good when I moved in. Well, you should not be charged with bringing that carpet, replacing it or bringing it back to being functionally brand new, because that's not the condition in which you moved into the unit. That's not what you paid for. That's not what you accepted at move-in. That's not what the landlord agreed to when they signed over that unit to you. So it's kind of an example beyond normal wear and tear. Security deposits have to be returned to you within 31 days of your lease terminating and of you moving out. If it's not returned in full, so if your security deposit was $1,000 and you get $995 back, well, in writing, there should also be a letter accompanying that check for $995 that says what they kept the $5 for. I know that sounds petty, and it kind of is, but it's just important because a landlord has to provide an itemized list. So they have to say this amount was kept from the security deposit for carpet, cleaning. This amount was kept because had to move furniture, had to call 1-800-JUNK and have them come pick up furniture left at the place. Things like that have to be clearly written out. there are certain things that, you know, you'd want to talk to a real professional about, such as what it means for them to, you know, what is normal wear and tear, what's reasonable, and also if they're giving you that itemized list, it doesn't mean always they have to prove with a receipt. They can also make reasonable estimations on what like that labor would look like. So that's where you're going to want to talk to somebody. And when you're trying to figure out whether you're being charged a reasonable security deposit or if you're being charged an unfair security deposit, you're going to want to look as to whether you're being asked to pay last month's rent with it. Because for a fixed term lease and just for leases in general, they tried not to, like, a security deposit shouldn't be more than what your monthly rent is. So if you're being asked to pay a security deposit in addition to last month's rent, you might want to talk to somebody, so you might be paying too much. But if you're being asked, so if your rent is $1,000 and they're saying you need to pay last month's rent up front, so you have to pay $1,000 right here, right now, then the maximum that they're going to be able to charge for a security deposit in addition to that last month's rent is half of whatever your monthly rent is. If that sounded confusing, it's because it is. And that's why I highly recommend talking to somebody about like your specific situation, and not just talking to somebody, but have them review your lease. Just, you never know what could be in there, and you just want to make sure there's no room for error. So now we're moving in. It's very exciting. We have the keys to our new unit. We're super, super excited to move in and live there, but we need to know a few things. And people feel free to respond in the chat, but does a rental agreement need to be in writing to be a valid lease? Fun answer time, big reveal. It depends. It depends is another legal term, like reasonable. That's sort of up to the eye of the beholder. But a rental agreement has to be in writing if it's for a year or longer, so 12 months or more. Then it does need to be in writing. But if it is not for a specific set of time and it's for, you just know that it's going to be for a few months, or you just know it'll be less than that 12-month period, then it can be just a spoken agreement. So I can say to you, yep, move on in. I'll rent you my, you know, I don't know, second bedroom that I don't have. But if I did, they're renting you a second bedroom. And just, you know, figure it out, just get back up on your feet after that. You know, you'll move out and we'll make things work from there. If those relations sour and then that person says, I'm violating their rights as a tenant, and I'm like, I'm not even your landlord, what are you talking about? Like, we never had a lease agreement. Ugh, well, that's going to get kind of sticky, because now this is going to be just an argument between us, right? And we don't have a lot of evidence, like a contract or a rental agreement, to say these were the terms that we agreed on. So it really is who can just make the better argument, who can support it, and who can get a judge to agree. That's not really a situation you want your housing to be in. So just to keep in mind. So here are some questions that I think are helpful when you're thinking about moving in. The first thing that I always tell people is take pictures. I'll say it many times. Take pictures, take a lot of them. Take videos. Get really all up in there on the floors, especially if you see a little scratch here, if you see something wrong with the wall here. Those little things, take pictures of all of it and then upload it somewhere where it saves when it was uploaded, a timestamp. So that way, if when you're moving out 6 months, a year, 2 years, 3 years down the road, and they're trying to say that a certain damage was done by you, and you're like, I did not do that. That damage is underneath the dryer. I've never moved the dryer in my entire tenancy here. Well, now you have something that has a date on it, that is photo evidence, that that damage was there day one when you moved in, wasn't you. So you want to take pictures of everything. But going through our who, what, where, when, and how, for who, when you're moving in, you really want to know who is the landlord, who is the property management company. You can find that information out. Usually, I mean, your lease agreement should say who you're in contract with. So it should either say the landlord's name or the management company that you're renting from. And you're going to want to know who's on your lease. So maybe you live in a house with, you know, only one other person, but that one other person is, you know, they have their partner, like their girlfriend, their boyfriend, their partner, their sibling, anybody, right? But who's coming in and staying there for a long time. You want to know that they're not on the lease because they're going to have different rights to that sort of space than you all do. It also means that if something goes wrong, the landlord is going to come for the people on the lease. And even if you and the other person on the lease or other people on the lease don't agree and think maybe one person should be responsible for all of the damage here, or maybe one person just dips, like you have a roommate and they disappear. They're not paying bills, they're not doing whatever, and you try to go to the landlord, you say, landlord, this person isn't paying, come get them, come make them pay. That's not the landlord's problem. That's your problem. In Oregon, everybody who's on that lease is what's called joint and severally liable. All that means is the landlord can come for one or all of you if you don't meet your obligations. So it's important who you sign leases with because you're in contract with them, but also you're now potentially liable, potentially responsible for their damage to a unit or their refusal or inability to pay the bills. So just know that landlords aren't there to resolve your dispute with your roommate, with your neighbors, perhaps, but what's going on with you and the other people that you chose to sign a lease with, that's not going to be a landlord problem. That's something that you're going to want to seek other resources or other counsel for. You're also going to want to know who is responsible for paying different utilities. Any utilities that the landlord is having you and your roommates pay for specifically should come out of a different sort of pool of funds. They have to say what utilities they are, that the tenant is responsible for, and any utilities that the landlord is going to be paying and then billing the tenants for all has to be in the lease. The rest of these are sort of like things that you might think of. The what are your duties? What are your responsibilities? What condition of the apartment? Where do you send rent? Where do you communicate? Where is your lease? Is it in an online portal? Is it in your email? Is it just a physical copy that you have? If you lose that also, you can just ask your landlord. They have to provide you with a copy of your lease. The whens, you're going to want to know when things are due, when your lease starts, when it ends, when is rent considered late. And then the how, again, comes back to how are you supposed to pay rent? Does your lease tell you that you are supposed to communicate with the landlord in a certain way? Do you have renter's insurance? Are you supposed to submit that to a portal? Do you need to send them some sort of specific confirmation that you have that renter's insurance? You just want to think about those types of things. We already talked about this. Take photos of everything. If you have Google, you can keep everything in a Google Drive. Google Photos is also a great way to just be able to take those pictures, put them in a folder, not think about it, possibly ever again, unless something comes up, and then you have that as a record. If you have a landlord that, you know, they talk to you a lot, but they don't actually confirm things in writing, it can be really helpful to just follow up. So say that you run into them in the mailroom or something, or out at the mailbox, and they make a promise, or they tell you that you can or can't, you know, tell you that you can do something. It's smart to just say, you know, following up on our conversation on X date or on whatever, you know, I'm confirming the following, or that we talked about this and came to this conclusion or agreed about this or that. Utilities, this is more for people to review on their own. But again, you have a right to know which utilities that you need to go and make an account with. So maybe PGE, right, for electricity. That might be on you to go have an account to make the payments to them separately, or maybe not. Maybe your landlord pays for the utilities bills and then sends you a bill and then you pay it back to them. You're just going to want to know those things. And another note here is just that a landlord can't retaliate against you for requesting repairs, for organizing, for doing anything by just like shutting off your water. If you aren't making payments, that could be a different sort of story, but just they're not allowed to try to make the conditions so unfavorable that you leave, especially if you've been making your payments. The renter's insurance is pretty common, especially in Portland, that different apartment complexes, different places will require that you have renter's insurance. They cannot require that you have a liability coverage for over 100,000. I have seen that come up. A lot of property development or property management companies are not from here, so they don't know about the different local Portland laws, and they definitely, they don't know about the state laws in a lot of cases too. So sometimes it's easy enough to just say like, hey, I see that you require this. Here's a quick link. $100,000 is the limit. And a lot of times they're like, thank you. Or they just don't respond and then they never enforce their $300,000 liability limit or whatever it is they were trying to demand. The other important renter's insurance thing is they cannot have any sort of clause or anything in the renter's agreement where it's like, in order to rent there, you're signing away your legal rights to file insurance claim against the property management's, or not the property management, the property's insurance. So they can't require you to waive your sort of legal right there in order to rent a place. During the tenancy, there's a lot of different things. Mainly, don't break the lease and know what the terms of the lease are. Is it a place where you can't smoke anywhere on the property? Are you trying to move somewhere, but you have a legal, that you have a legal prescription to use marijuana, but it's a non-smoking sort of building completely. That's a hard rule. Those are things you're going to want to figure out before before you're in there. Make sure you're paying rent on time. Most rent is due on the 1st, and it's not considered late until after the 4th day. So that means on the 5th is when you would be eligible to have to pay a late fee. And only after that would they be, after the 5th is when they would be able to provide the steps for eviction. But that's a whole separate sort of time clock. But just know that if you receive a notice for non-payment of rent, that's not the same thing as like an eviction notice or a court summons. And so just a thing, don't freak out yet. You get something like that, you still have an opportunity to be able to pay up what you owe, to pay your rent, pay the late fee. And that's called a tenant remedy or a tenant ability to cure. You're going to want to request repairs when things are happening. That's mostly because if the damage gets worse and they can prove that there was clearly a visible like water leak or something like that you just didn't deal with, then they might try to come for you to pay for the entirety of what that repair costs, even though it wasn't your fault to begin with. But the fact that it got worse, they're probably going to argue was your fault. Testing the smoke and carbon monoxide alarms. I'm sure we all do that every 6 months, like clockwork. We're all just checking our alarm systems because we're just great people. But if that doesn't happen, just make sure that before you leave, when you return the unit, that it has fresh batteries. Again, you should be safe and you should always put the batteries in 6 months apart, but definitely do so before the end of your tenancy. Same thing with air filters. Some landlords will send air filters to you every like 3 months or whatever it is for their unit. others won't. So make sure to check those, because also if you have asthma or you just like have any sort of sensitivities, and with all the wildfires and stuff we have here, the filters get dirty pretty fast. So it's a good thing to check out just for your health. Don't disturb your neighbors, and maintain accurate records. Take photos and save everything somewhere you can find it. And don't just save it on your, computer, because if something happens to your computer, it's gone. Don't just save photos on your phone, because if something happens to your phone, they're gone. You must take them and then upload them to that magical cloud that's out there, just all around us, because that way you actually have something to track you. We talked about rent. Most rent is due the first of the month and is not considered late until after the 4th day. To charge a late fee, the landlord has to state what that fee will be in the rental agreement, and that a fee would be charged at all, and that fee can't exceed 5% of the monthly rent amount. So they can't say, oh, you were late, $1,000 late fee. No, can only, if it was in $1,000 rent, it could only be $50. And there's a process that they have to follow in order to charge that fee. The landlord also has to do things. They have to make sure that you have a safe and clean home to live in within reason. They don't have to come in and clean your home, but like the area to get to your home. You shouldn't have, rats, like a big rat's nest right in front of your front door. You shouldn't have a bunch of trash in the common areas. Like those are things that it is the landlord's responsibility to make sure are taken care of. And they have to provide whatever services. Just like I told you to know what your lease says, they need to know what the lease says too, because they're also saying that they're going to maintain the property in a certain way. And one big thing is that they have to respect your right to exclusive possession. So what that means is even if they're the homeowner, even if they own your building, they can't just wander in and out as they please. If you're renting like a full house and that house has a yard, and all of a sudden you look out your back window and your landlord's just wandering around in your yard, and they did not give you notice, you did not give them permission, nothing like that, that is a violation of your tenant's rights. So important. They do own the home, but they have to provide you at least 24 hours of notice, unless there's an emergency that would get worse without them coming into the unit. So if you can think of like, say that somebody lives on like the 2nd floor and a pipe bursts, but they're out of town, and now the water is like coming into other units, it's causing a lot of damage. Well, then in that case, the landlord would be able to go in and have like maintenance folks go in. They still have to notify the tenant. And they also have to notify the tenant like who was in their space and why and when. So they still have to tell you after the fact. They can't just run around in there and you would never know. But typically they're supposed to provide 24 hours notice. Habitability issues is something I think is a great opportunity for organizing. This is where things like mold, weatherproofing, just structural safety, having working, water, stuff like that is all going to be considered habitability, because those are about our basic living standards that a rental should have in order to be fit for humans to live in. And habitability issues are things that can trigger a different timetable. So if you make certain complaints about, say, temperature, like your heat breaks and it's 15 degrees outside, it might be really challenging for them to be able to get repair to you, but they do have to respond to your repair request within a certain amount of time and have those repairs made, because of the fact that it can impact like people's health and well-being. So habitability is kind of a special word to just keep in mind, especially if you've had issues around repairs. One area that, just like the discrimination and retaliation, I find very frustrating is mold. There's mold everywhere here, and there's mold that makes people really sick in Portland, but we don't have the best enforcement, right? Or processes for kind of fighting back against mold, or getting landlords or the city, state to sort of step in and take care of that. So another great opportunity for advocacy, but technically, if you're identifying a health concern, that should be dealt with quickly. Repairs. We talked about, on the right here, you can review on at your leisure what different steps could be for getting repairs. Depends on what they are. The only thing I want to draw attention to is this bullet that says withhold rent if unresolved and repair and deduct. Anytime that something tells people that they should withhold rent, I get really nervous because the process, even though there are tenant protections, the non-payment of rent process, there's a whole system and timeline, and evictions happen very quickly. Fighting against those things can be a lot slower. It can take a lot more time. So if you're able to pay rent and still fight the good fight, that's typically what I would think is a maybe more sensible or more cautious option, because at least that way you might be getting, that money reimbursed, or you might be getting money back in the future, but you're doing so without risking an eviction notice or without risking losing where you're living right now. But that's up to you, and it's very situational and dependent, but talk to lawyers, talk to people before you withhold money. When you withhold people's money, they get real fighty about it. And so it's good to, before you're ever going to withhold anything, make sure that you're in the right, and make sure that you're not about to risk a lot to deal with an issue that maybe could have been dealt with otherwise. This we talked about already, your right of exclusive possession, meaning your landlord can't just wander around in your space. Right to organize is important. You have the rights to be able to organize with other tenants, to talk to people about issues you're going through without the landlord retaliating against you. And then it looks like we're right here at 729 for the move out process. We covered a lot of this throughout, but if I'm going through it quickly, just know that if you're dealing with situations like domestic violence or uninhabitable living conditions, you as a tenant might have other ways to be able to terminate your tenancy without suffering the lease break penalty or things like that. Those situations are pretty specific. Feel free to reach out to our email if you think you're in one of those situations, and we can try to connect you to some resources. But the rest of this is just take photos, try to get the landlord to do inspections with you, just so that you can hold them accountable and they can't try to say that a bunch of damage was done that you don't think was there. And whatever the date is that you move out, like the end of your lease, date. So if mine was July 23rd, I would literally type into the internet, what is 31 days from July 23rd, 2024? And whatever that date is, it plops back out. I'm going to set an alarm on my phone so that I know to be checking my mail. And then if I don't have a check with my security deposit and a letter that's saying what they kept money for, that now I am going to contact a legal representative. I am going to contact community lines of tenants, because the penalty for a landlord not giving that to you within that period of time is 1.5 times your monthly rent. So that can be substantial. But I will stop my sharing now because I want to make